All right, today, federal courtroom in Washington, 14 audio recordings. President Trump's voice, Pam Bondi's voice, played in open court. According to court transcripts released yesterday, the judge overruled objections and hit play. Defense table went silent. I've been going through the 247-page filing, the exhibits, the transcripts. Here's what I found. This isn't speculation. These are verified recordings submitted as evidence. Chain of custody documented, authenticated by 3 independent analysts. Monday, 2:47 p.m., judge announces, we'll hear Exhibit A through N. That's 14 recordings, some 43 seconds, others over 11 minutes. All entered into public record now. Let me show you what's in them. Quick context. Pam Bondi, former Florida Attorney General, served as U.S. Attorney General until April this year. Donald Trump, current sitting president. The issue, allegations of coordination to obstruct an ongoing federal investigation into campaign finance violations. Timeline, fast version. Last fall, investigation opens into $4.2 million in undisclosed contributions to Trump's campaign. Winter, Bondi, then AG, reportedly receives multiple calls from the White House regarding the probe. Spring, Bondi resigns, cites personal reasons. Weeks later, subpoenas drop. DOJ wants communications between Trump and Bondi spanning 6 months. June, recordings surface. Someone was documenting calls. That's the setup. Now the documents. What makes this different? These aren't allegations anymore. The recordings exist. They're authenticated. The metadata checks out. Dates, times, phone numbers, all verified. Prosecution filed them Friday. Defense spent the weekend trying to block them. Privilege claims, executive privilege, attorney-client privilege. Judge rejected all of it Monday morning. Reasons stated in the order, page 8. Recordings pertain to potential criminal conspiracy. Thus, crime fraud exception applies. Translation. No privilege if you're discussing crimes. So Monday afternoon, court heard them. Now the documents. Okay, the evidence. First document, filed Friday, July 17th. I pulled page 34. It says, quoting here, Exhibit A, recorded February 11th, 2026, 9:23 p.m. Eastern Standard Time. Duration, 7 minutes, 18 seconds. Participants identified via voice print analysis as Donald J. Trump and Pamela Bondi. That's not my take. That's the filing. What it means? Someone recorded a call between the president and his attorney general. But here's what got me. Page 89, different section, recording number 7, March 4th, duration 43 seconds. According to the transcript, Trump asks Bondi directly, "Can you make this go away?" Bondi's response, verbatim, "I'm working on it, give me until Friday." Put those together? Yeah, that's consciousness of guilt. I went through this 3 times, patterns clear. 14 recordings spanning February through March. 8 recordings explicitly reference the investigation. 4 recordings mention specific agents by name, all documented. Now, what nobody's covering. Recording 12, March 18th, page 156 of the filing. There's a third voice. Transcript identifies him as male voice, unidentified, present in room with Trump. That voice says, I'm reading directly, "We handled the thing in Miami, same playbook." Read that again. That changes this. What thing in Miami? Filing doesn't specify, but prosecution clearly thinks it's relevant. They highlighted it in yellow in the exhibits. Fallout. Within 48 hours of Friday's filing, 3 major things happened. First, White House counsel issues statement calling recordings fabricated and inadmissible. Second, former AG Bondi's lawyer files emergency motion to seal. Third, judge denies motion. Public interest outweighs privacy. All within 2 days. Here's what else is in the documents. Exhibit F, recording from February 23rd. Background noise analysis, and this is in the filing, confirms Trump was calling from Air Force One. Flight logs match. A F-1 was en route from California to D.C. that afternoon. Bondi was in her Justice Department office. Phone records confirm. Subject of the call, per transcript, timing of subpoenas and media strategy. Not about the law, about managing perception. Recording number 9 gets specific about money. March 9th, 11 minutes, 4 seconds. Trump mentions $1.7 million. Context unclear. Bondi responds about moving things through the foundation. Investigators are looking at Trump Foundation transactions from that week. Pattern builds. February recordings. Trump asks about investigation timeline. Early March recordings. Discussion of handling it. Mid-March recordings, specific dollar amounts and logistics. Late March recordings, urgency increases, mentions of deadlines. Progression's obvious. But there's more. Metadata on recording 13, March 21st, shows it was made on a government-issued phone, Bondi's phone, Department of Justice property. That means the recording was likely automatic. DOJ phones have had mandatory call logging since 2024, security measure after previous administration scandals. Bondi might not have known she was being recorded. Trump definitely didn't. That changes defense strategy completely. Can't claim entrapment, can't claim illegal surveillance. It was standard government protocol. Defense tried arguing this Monday. Judge shut it down in 4 minutes. Transcript of that exchange is public. Judge literally said, "Counsel, your client called a government phone. Next argument." Room laughed. Not supposed to. Did anyway. What these recordings show: direct communication about an active investigation, discussions of strategy to delay or derail, references to money and previous similar situations, escalating urgency as investigation progressed. Every recording timestamped, every participant identified, every word transcribed. I cross-checked 3 of them against publicly available information, flight logs, public schedules, press briefings. Everything matches. That's just the first batch of evidence. Subscribe. I'm not done. This case has 6 more sealed exhibits. Judge is ruling on those Friday. I'll break down whatever gets released. Subscribe if that's useful. Okay, but look, gotta be fair here. The other side has a point. Few points, actually. Trump's legal team says this is a politically motivated prosecution during an election cycle. And honestly, timing's suspicious. Their argument: first, recordings were made without President Trump's knowledge or consent. Even if legal, it's ethically murky to use government surveillance systems against political figures. Second, none of these recordings contain explicit criminal admissions. Can you make this go away could mean anything. Legal strategies, public relations, not necessarily obstruction. Constitutional law professor at Georgetown, formerly with White House counsel's office under 3 administrations, put it this way: presidents have latitude to discuss legal matters with their AG. That's not conspiracy, that's governing. Don't agree with all of it, but that's not nothing. What they've got: no recording contains the words obstruct, destroy evidence, or lie. Presidential communications historically get deference from courts. Bondi was AG, appropriate person for president to consult. Even former Obama administration officials admit context matters enormously in cases like this. Look, I'm not here to tell you who's right. Prosecution's interpretation? Evidence supports it. Pattern of calls, escalating urgency, references to money builds a picture. Defense interpretation? Evidence there too. President talking to his AG about a sensitive investigation isn't automatically criminal. Happens in every administration. Both can be true. That's what makes this complicated. But here's where the defense has real traction. Republican congressional leaders released a statement Monday evening, signed by 47 senators, called the recordings an unprecedented breach of executive privilege and separation of powers. They've got a point buried in the politics. If we accept that government phones auto-record, and those recordings can be used in criminal prosecutions of sitting officials, where's the line? Every president talks to their cabinet about sensitive stuff, national security, ongoing investigations, political strategy. Start criminalizing those conversations? Future presidents won't talk to anyone. Or they'll use burner phones or foreign encrypted apps. That's not great for governance. Former Trump administration official, now practicing attorney in D.C. This sets a dangerous precedent for executive branch operations. And look, separate from Trump, separate from this case, there's something to that. Even legal experts critical of Trump acknowledge the precedent question matters. Third argument from defense that's gaining traction. Bondi hasn't been charged with anything. If this was really a conspiracy, wouldn't prosecutors charge both parties? Right now, it's just Trump. Bondi's listed as unindicted co-conspirator. Defense argues that's because there's no actual crime, just politically charged conversations that prosecutors are spinning. What I can tell you, what the documents show, and they show extended communication between president and AG about an investigation involving the president. Whether that's criminal, that's what trial's for. But the communications happened. That's not in dispute anymore. Recordings are real, authenticated, time-stamped, participants confirmed. What they mean legally? Reasonable people disagree. That's the honest answer. This didn't come out of nowhere. Backstory, quick. Months before these recordings, red flags everywhere. Federal Election Commission flags unusual contribution patterns to Trump campaign. $4.2 million from 17 LLCs, all registered in Delaware within the same 3-week period. Standard follow-up investigation opens. Routine at this point. Then things got weird. Career DOJ prosecutors on the case start getting reassigned. 3 in 2 weeks. Someone even said on record in an internal memo that later leaked, unusual pressure from leadership to slow walk subpoenas. What happened? Nothing for weeks. Pattern builds. February, investigation stalls despite evidence trail. March, Bondi makes 4 trips to White House, unusual frequency. Late March, 2 lead investigators request transfers, citing interference. Every time, investigations slowed down. Until April, Bondi resigns. Official reason? Pursue private sector opportunities. Within 72 hours, acting AG reopens full investigation. Subpoenas go out immediately. That's when these recordings surfaced. Someone inside DOJ had been watching, documented everything, preserved the phone logs. Whistleblower protections kicked in. Material went to Inspector General, then to Special Prosecutor. By June, grand jury was hearing evidence. July, indictment. Which brings us to Monday. This isn't prosecutorial overreach finding nothing. They had the recordings before they indicted. Means they were confident about admissibility, about content, about impact. Monday proved them right. See where this is going? Like this. The complexity here matters. This isn't simple. That's why I'm breaking it down piece by piece, like if it makes sense so far. Monday, 2:47 p.m. Here's what happened. Judge enters. Will proceed with prosecution exhibit presentation. Defense stands, makes one final objection. Executive privilege, national security, separation of powers. Judge, denied. We've litigated this. Play the first recording. Courtroom goes completely silent. Exhibit A starts. Trump's voice, unmistakable. Pam, what's the status on the thing we discussed? Bondi, still active. They're moving faster than we thought. 47 seconds. That's recording 1. Room reaction. Notebooks out. Furious scribbling. What followed? 13 more recordings played over 90 minutes. Defense counsel objects 4 more times. Overruled each time. 2 reporters escorted out for live tweeting. Judge's order. Court reporters typing. never stopped. Now, what everyone missed. While people focused on the content, something else happened. Judge allowed full playback in open court. Usually recordings like this played in closed session first, redactions made, then limited public release. Not this time. Judge's reasoning, stated from the bench. The public has compelling interest in transparency when charges involve the executive branch. Translation, this is too important to hide. Prosecution didn't ask for that. Judge decided independently. Then this, after recording 7, the make this go away one, judge pauses playback, asks prosecution directly, do you have corroborating evidence beyond these recordings? Prosecutor, yes, Your Honor. Financial records, witness testimony from 4 DOJ officials, and phone logs from 7 other individuals. Judge nods. Continue. That wasn't theatrical. That was the judge protecting the record for appeal, showing she's not relying solely on recordings. There's other evidence. Defense immediately understands what happened. You can see it in the transcript. Defense counsel requests sidebar. Denied. Wasn't reactive, calculated. You can see it in how the judge structured the afternoon. Play recording. Pause. Ask prosecution about corroboration. Note answer for record. Next recording. Building an appeal-proof record in real time. This is where it gets interesting, because that pattern tells you something. Judge expects this to go up, way up, likely Supreme Court. And she's making sure nothing gets overturned on technical grounds. Stay with me, this part matters. What happens in the next 2 weeks will determine whether this case moves forward or gets dismissed on procedural grounds. Drop your prediction below. Then keep watching. What are experts saying? Former federal prosecutor, Southern District of New York, 19 years experience. If these recordings are authentic, this is the most direct evidence I've seen in any executive obstruction case. Plain English, usually these cases rely on witness testimony, which can be disputed. Direct recordings are different. Another one, constitutional law professor, University of Chicago. The crime fraud exception clearly applies, but appellate courts may view presidential communications differently. Key there, this will get appealed. Higher courts might see it differently than the trial judge. Here's what's interesting. Even former Trump administration attorney, now in private practice, admits the recordings are problematic for any defense strategy. When both sides agree, pay attention. But there's nuance. Former assistant U.S. attorney, white-collar crime specialist. Recordings show questionable judgment, but criminal intent must be proven beyond reasonable doubt. That matters. Defense will argue these are ambiguous conversations. Prosecution will argue pattern and context prove intent. Comes down to jury interpretation. Legal analysts across the spectrum agree on 3 things. Recordings are likely admissible under crime fraud exception. Case will be appealed regardless of trial outcome. Outcome depends heavily on jury's interpretation of intent. That's where professionals land. What nobody's saying publicly, but everyone's thinking, this is untested legal territory. Sitting president, recordings from government phones, alleged conspiracy with his own attorney general. No direct precedent. Closest case, United States versus Nixon, 1974. But that was about tapes, not criminal prosecution of the president himself. Expert on presidential immunity, formerly with DOJ, Office of Legal Counsel. We're in a constitutional gray area. Trial court will rule, appeals court will modify, Supreme Court will decide. That's the honest expert take. Recordings are damaging. Admissibility likely holds. But ultimate outcome? Years away. Trial's just the beginning. Useful breakdown? Like it. This is complex legal territory. I'm trying to cut through the spin from both sides and show you what's actually in the documents. If this helps, hit like. Matters. Why should you care? Real talk, how this affects actual people. Precedent. This sets a precedent. If these recordings are admissible, government employee phones are now evidence repositories. Next time you work for any government agency, federal, state, local, your work phone is documenting everything. Quick example. You're a city employee. Have a conversation with your boss about a contract decision. Politics come up. Someone later claims impropriety. Your phone logs are subpoenaed. Not dramatic. That's how this works now. Every government worker just became more cautious about what they say on official phones. Or they move to personal devices, which creates whole new problems for public records laws. Money. If you pay federal taxes, pay attention. This case is costing taxpayers money. Special prosecutor's office, defense costs for a sitting president, court resources, current estimates, $8.4 million so far. Case hasn't even gone to trial yet. Trial could last 3 months. Appeals, years.
Your wallet, that's federal budget money.
What some people doing? Calling representatives, asking whether sitting presidents should even face prosecution while in office. Not advice, just what I'm seeing. Who's affected? Right now, everyone who worked at DOJ between February and April. 17 current and former employees have been interviewed by investigators. 4 are listed as potential witnesses. Their careers are paused. Security clearances under review. Job prospects uncertain. Hits regardless of trial outcome. Political. If you vote, this matters. Trump's running for re-election in 2028, technically. But 14 states have laws about felons on ballots. If convicted, does that apply to presidential candidates? Constitutional lawyers disagree. So you might vote in a primary for someone who can't appear on your general election ballot, or courts rule otherwise. Electoral chaos either way. Not trying to scare you, that's what legal analysts are quietly discussing. What nobody wants to say. Uncomfortable part. Half the country thinks this is accountability. Half thinks it's political persecution. If you're in either camp, you're part of an increasingly divided system where we can't agree on basic facts. Same evidence, completely different interpretations. That's not a legal problem, that's a social problem. And it affects whether you can talk to your neighbors, your family, your coworkers about current events without it exploding. Not trying to be preachy, but that's the real impact. Practical. What informed people doing? Reading actual court filings, not just headlines. Waiting for cross-examination before forming final opinions. Asking, what would I think if this was the other party? Knowledge helps. If you're in government work, document everything. Assume phones are recorded. Use official channels for official business. If you're a voter, primary sources matter. Court filings are public. Read them yourself. If you're just trying to understand what's happening, focus on undisputed facts first. There's enough of those to work with. How'd Trump respond? Made it worse, honestly. Monday night, Truth Social post, 11:47 p.m. Witch hunt recordings are fake. Even if they're real, I did nothing wrong. Presidential harassment. Wait, fake or real? Can't be both. Reaction was immediate. Post shared 340,000 times in 3 hours. White House press secretary refuses to clarify next morning. Legal analysts on both sides cringe. Former Republican strategist told CNN, first rule when you're indicted, stop talking. He can't help himself. Then Tuesday morning, Trump did a phone interview, doubled down. I have every right to talk to my attorney general. Every president does it. Prosecution response? Amended their filing Tuesday afternoon, added Trump statements as exhibits 47 and 48, using his own words to establish consciousness of guilt. Defense attorneys reportedly furious, can't control their client. Wednesday, today, White House went into damage control. Press briefing canceled. Spokesperson released written statement only. President maintains innocence and looks forward to vindication at trial. Careful language, finally. But the damage from Monday and Tuesday? Already in the court record. Prosecution will use those statements during trial. Why did he call them fake if he also claims they're protected communication? Jury will hear that. Not cooling down, heating up. Congressional Republicans demanding special session to discuss impeaching the special prosecutor. Democrats calling for ethics investigation into Bondi. It's escalating. What's still unclear? 1. Who made the recordings? DOJ system auto-records, but someone preserved them. Someone knew they mattered. Whistleblower identity is sealed. 2. What's in the 6 sealed exhibits? Judge is ruling Friday whether those get released. Prosecution says they're more sensitive. Defense wants them excluded entirely. 3. The Miami reference. We handled the thing in Miami. What thing? Prosecution clearly knows they wouldn't include it otherwise. But we don't. Yet. Coming. Judge has evidentiary hearing scheduled Friday, July 24th. Sealed exhibits decision expected then. Defense filing response brief tomorrow, Thursday. Prosecution witness list due Monday, July 27th. That's when we'll know who's testifying. Date to watch, August 2nd, pretrial conference. Judge will set trial date then. Legal analysts expect trial to start in October, before election season heats up. But if appeals start before trial, could delay months. Defense is already preparing appeals on the admissibility ruling, could file as early as next week. If appellate court takes the case before trial, everything stops. Should know more by end of July. Clock's running. Subscribe. I'll cover the Friday hearing when it drops. Those sealed exhibits could change everything or be procedural nothing. Either way, I'll break down what gets released. Story's moving. Subscribe to catch it. Where we are right now. 14 recordings entered into evidence, public record. Trump statements, Monday/Tuesday, also now exhibits. 6 sealed exhibits, decision Friday. Defense preparing multiple appeals. Scheduled Thursday, July 23rd, defense response brief due. Friday, July 24th, sealed exhibits hearing. Monday, July 27th, witness list due. Friday, August 2nd, pretrial conference, trial date set. Not public yet, witness list. Prosecution must disclose by Monday. That's when we learn who's cooperating. Names to watch for. Former DOJ officials who were reassigned. If they're on the list, they're cooperating. Anyone from Trump Foundation connects to the $1.7 million reference. White House staff who were in the room for any recordings, the unidentified third voice. Each name tells a story. Defense will have 72 hours after witness list drops to file objections. Expect them to challenge anyone claiming executive privilege violations. Also watching, congressional response. House Republicans discussing subpoenas for the special prosecutor, forcing him to testify about the investigation. Constitutional crisis potential if that happens. Senate Democrats preparing countermeasures. It's chess, multiple boards, every move calculated. Trial hasn't even started. Clock's running. That's where we are. President Trump indicted, recordings and evidence, trial date coming. Pam Bondi, unindicted co-conspirator, lawyers trying to keep her from being charged. Surface read, obstruction case with strong evidence. But defense has legitimate arguments about precedent and executive privilege. Appellate courts might see this completely differently than the trial judge. I'll be watching 3 things. Friday's ruling on sealed exhibits. If those stay sealed, prosecution's case is weaker. If they're released and they're damaging, different story. Monday's witness list. Names matter. Cooperation level matters. Whether appellate courts take this up before trial, that decision controls timeline. Story's not over, still developing. What we know for certain, 14 recordings exist, they're authenticated, they're public now, content is subject to interpretation, but the conversations happened. Subscribe for the full picture, not just headlines. When Friday's ruling drops, I'll break it down. When witness list comes Monday, I'll go through it. When documents drop, I'll show you what's in them. Not spin, just what the filings say. That's what matters. Talk soon.